Imagine a single company controlling 90% of the world's most essential software. By 1998, that was Microsoft, and the United States government decided it was too much. On May 18, 1998, the U.S. Department of Justice, alongside 20 states, filed antitrust lawsuits, claiming Microsoft had built an illegal monopoly. This wasn't just about market dominance. It was about how Microsoft allegedly used its Windows operating system to crush competitors, particularly Netscape's Navigator web browser. The core allegation was that Microsoft tied its Internet Explorer browser directly into Windows, making it incredibly difficult for other browsers to compete. This monumental legal battle would redefine how we understand technology monopolies, and its impact still shapes the digital landscape in 2026. What exactly did the courts find, and how did this case forever change the tech industry? On May 18, 1998, the United States Department of Justice, joined by 20 states and the District of Columbia, filed a civil action that would reverberate through the burgeoning digital economy. Their target, Microsoft Corporation, an entity then valued in the hundreds of billions, and its widely adopted Windows operating system. This was not merely another legal dispute. It was a fundamental challenge to the power structure of the digital age, alleging that Microsoft had engaged in an unlawful monopoly. The allegations were stark: that Microsoft had leveraged its dominant position in operating systems to stifle competition, particularly in the nascent Internet browser market, primarily through the bundling of its Internet Explorer with Windows. This legal saga wasn't born overnight. It had roots stretching back to 1990, when the Federal Trade Commission first began investigating Microsoft's tie-in sales practices, with the Department of Justice taking over in 1993. What unfolded was a complex legal battle that spanned years, involved high-stakes courtroom drama, and ultimately reshaped how regulatory bodies view and address market dominance in technology. This case, U.S. v. Microsoft Corp., wasn't just about a single company. It asked profound questions about innovation, consumer choice, and the limits of corporate power in an era defined by rapid technological advancement. It set precedents that continue to influence antitrust enforcement today. We'll begin by examining the initial complaints filed by the Justice Department and the state attorneys general, detailing the specific allegations against Microsoft's business practices. This monumental legal challenge didn't emerge from a vacuum. The seeds of suspicion regarding Microsoft's market dominance were sown much earlier, with federal regulators initiating investigations nearly a decade prior to the pivotal 1998 lawsuit. As early as 1990, the Federal Trade Commission, or FTC, under then-Chairman Janet Steiger, began scrutinizing Microsoft's marketing practices with a focus on their rapidly expanding software empire. Their initial concerns centered on what they termed tie-in sales, specifically, Microsoft's aggressive strategy of bundling its applications, most notably MS-DOS and later early versions of Microsoft Works, directly with its widely adopted Windows operating system. This practice, perceived as leveraging Windows' near monopoly to push other products, raised early red flags for potential anti-competitive behavior, particularly against nascent competitors like WordPerfect and Lotus 123. The federal government's involvement escalated significantly in 1993, when the Department of Justice, or DOJ, led by Attorney General Janet Reno, took over the investigation from the FTC. This transfer signaled a heightened level of concern within the executive branch about Microsoft's growing power in the burgeoning software market, which by then controlled over 80% of PC operating systems. By 1994, the DOJ and Microsoft had reached a settlement known as the Microsoft Consent Decree. This agreement, designed to regulate Microsoft's marketing practices and prevent what the DOJ considered exclusionary tactics like preprocessor licensing, was a significant, albeit limited, intervention. However, this proved to be only a temporary reprieve. Despite the 1994 settlement, the underlying issues of market control and alleged anti-competitive conduct, especially concerning the integration of Internet Explorer with Windows 95, continued to simmer. Microsoft's relentless pursuit of dominance, combined with concerns from competitors like Netscape Communications and Sun Microsystems, ultimately led to the government's decision to escalate its actions further. The stage was set, and the gauntlet was about to be thrown. On May 18, 1998, the formal gauntlet was decisively thrown. The United States Department of Justice, now powerfully augmented by the attorneys general of 20 states and the District of Columbia, initiated sweeping civil actions against Microsoft Corporation. This was no minor regulatory squabble. The central allegation was that Microsoft systematically maintained an unlawful monopoly in the personal computer operating system market, primarily through its ubiquitous Windows platform, in direct violation of Sections 1 and 2 of the Sherman Antitrust Act of 1890. The complaints were meticulously precise, detailing a pattern of anti-competitive conduct. Prosecutors, led by the formidable United States Attorney General Janet Reno and the influential state of New York ex-rel. Attorney General Eliot Spitzer, argued that Microsoft was leveraging its existing near-monopoly position in the Windows operating system, which commanded over 90% of the desktop market, to unfairly extend its dominance into the burgeoning web browser market. Their laser focus was largely on the alleged strategic suppression of Netscape Navigator, which, in 1995, held a staggering 80% market share, but had seen its position erode rapidly. The complaints, bearing civil action nos. 98-1232, TPJ and 98-1233, TPJ, painted a damning picture of a company actively stifling innovation and limiting consumer choice to solidify its market position. Specific accusations included the aggressive bundling of Internet Explorer with Windows 95 and 98, making it exceedingly difficult for competing browsers like Netscape to gain traction or even be pre-installed by PC manufacturers such as Compaq and Dell. This monumental filing set the stage for extensive and groundbreaking legal proceedings. The landmark bench trial, presided over by U.S. District Judge Thomas Penfield Jackson, officially commenced later that year, on October 19, 1998, ushering in months of intense testimony from industry titans like Bill Gates and Jim Barksdale, voluminous evidence presentation, and complex legal arguments that would captivate both the global tech industry and the legal world. The trial itself, United States of America v. Microsoft Corporation, Civil Action No. 98-1232, TPJ, alongside a parallel action by the state of New York, Civil Action No. 98-1233, TPJ, was a protracted and intricate affair. It featured extensive testimony, with the plaintiffs calling 6 witnesses and Microsoft presenting 19, including numerous expert economists and computer scientists. A core of the government's case, argued by attorneys representing the Justice Department and 19 states, rested on the contention that Microsoft illegally monopolized the web browser market for Windows by bundling Internet Explorer with its operating system, thereby restricting competition from rivals like Netscape. Among the plaintiff's key expert witnesses were Dr. Andrew Appel, a professor of computer science at Princeton University, and Dr. Carl Shapiro, a professor of business strategy at the University of California at Berkeley, who provided detailed economic analysis of market dynamics. Economist Franklin M. Fisher also delivered direct testimony for the plaintiffs, meticulously outlining Microsoft's market power and alleged anti-competitive practices. For instance, the prosecution emphasized how the integration of Internet Explorer with Windows made it virtually impossible for competing browsers to gain a significant foothold. By September 21, 1999, as final arguments were presented, Microsoft, represented in its legal affairs by Senior VP William H. Newcomb, maintained that the government failed to prove its case against the software maker. However, the court's findings of fact document, a searing 207-page assessment issued in November by Judge Thomas Penfield Jackson, strongly rejected Microsoft's arguments. These findings meticulously outlined Microsoft's significant power in the relevant market and foreshadowed the judicial rulings and appeals that would soon follow. The trial's conclusion initiated a complex series of judicial rulings and appeals. The initial final judgment in the consolidated cases of U.S. v. Microsoft Corporation and State of New York, et al. V. Microsoft Corporation, was formally filed on June 7, 2000. In this ruling, Judge Thomas Penfield Jackson, of the U.S. District Court for the District of Columbia, found that Microsoft had indeed violated Sections 1 and 2 of the Sherman Antitrust Act. To remedy these violations, Judge Jackson issued a controversial order mandating the structural breakup of Microsoft into 2 separate entities, one to develop operating systems and another to handle software applications. This order, however, was immediately stayed pending appeal. The case then moved to the United States Court of Appeals for the District of Columbia Circuit. Arguments were heard over 2 days, on February 26 and 27, 2001, before a 7-judge panel. The Court of Appeals delivered its pivotal decision on June 28, 2001. In a significant, though partial, victory for the government, the appellate court largely upheld the finding that Microsoft had engaged in monopolistic behavior by unlawfully maintaining its dominant position in the operating system market. However, the Court of Appeals vacated Judge Jackson's order to break up Microsoft, deeming it an excessive and potentially harmful remedy. This ruling by the appellate court followed a crucial shift in the government's stance. On September 6, 2001, the U.S. Justice Department, under the administration of President George W. Bush, announced that it no longer sought Microsoft's breakup. This decision signaled a substantial change in the government's desired outcome, moving away from structural remedies towards behavioral ones. The appellate court's decision also remanded the case back to the district court for further proceedings consistent with its findings. The subsequent path, however, would lead not to another trial but to a negotiated settlement. The protracted legal battle ultimately culminated in a pivotal settlement. On November 1, 2002, Judge Colleen Collar-Coadley of the U.S. District Court for the District of Columbia formally ruled that a proposed settlement served the public interest, thereby fulfilling the stringent standards set by the Tunney Act, 15 U.S.C. Section 16(e). This judicial confirmation effectively ended the government's pursuit of a breakup of Microsoft, a key point of contention after the initial findings of fact released by Judge Thomas Penfield Jackson. The settlement agreement, rather than dismantling the formidable Redmond-based technology giant, focused intently on curbing Microsoft's documented anti-competitive practices, particularly in its bundling of Internet Explorer with Windows. It imposed specific, actionable restrictions on its behavior within the operating system and software markets. For instance, the agreement mandated that Microsoft allow computer manufacturers, such as Dell and HP, to install non-Microsoft middleware, like Sun Microsystems' Java Virtual Machine or Netscape Navigator, on Windows machines. This aimed to foster greater competition at the desktop level, moving beyond the perceived monopoly leveraging. This decision represented a significant pivot from the initial judicial inclination towards structural remedies, as outlined in Judge Jackson's earlier rulings. United States v. Microsoft Corp., officially recorded at 253 F3D 34, D.C. Sir. 2001, became a landmark American antitrust case. It profoundly influenced subsequent antitrust enforcement, particularly concerning the rapidly evolving technology sector and the rise of platform businesses like Google and Facebook, for years to come. The case underscored the inherent challenges of regulating markets defined by swift technological advancement and the immense power wielded by dominant software platforms. It served as a stark demonstration of how a company could leverage its market dominance in one area, such as operating systems with Windows owning over 90% market share at the time, to gain an unfair advantage in related markets. This video presents publicly documented information. It is for educational purposes, not legal advice. The protracted legal battle ultimately culminated in a pivotal settlement. On November 1, 2002, Judge Colleen Collar-Coadley of the U.S. District Court for the District of Columbia formally ruled that a proposed settlement served the public interest, thereby fulfilling the stringent standards set by the Tunney Act, 15 U.S.C. Section 16(e). This judicial confirmation effectively ended the government's pursuit of a breakup. The Microsoft antitrust case, initiated in 1998, ultimately redefined the boundaries of competition in the digital age. It established a significant precedent for how dominant technology companies could be regulated, influencing subsequent legal challenges and legislative considerations for Internet platforms and software developers. The rulings underscored the judiciary's role in balancing innovation with maintaining a competitive market, a debate that continues to shape regulatory approaches to major tech entities in 2026. This case raises fundamental questions about the nature of market dominance in rapidly evolving technological landscapes. Did the settlement ultimately foster a truly more competitive software landscape, or merely temper the growth of one giant while others rose? Share your insights on how this case might have influenced the tech world you navigate today. To understand more landmark legal cases and their enduring impact, subscribe to this channel for in-depth legal analyses. If you found this breakdown illuminating, I highly recommend watching my video on FTC v. Meta platforms, which further explores the evolving challenges of antitrust enforcement in the digital realm. This video presents publicly documented information. It is for educational purposes, not legal advice.